All right, lawyer talk off the record, on the air. They don't teach you that in law school. Got Troy right here. Troy Hendrickson, a Capital University law student, second year, halfway through.
Halfway through.
Gotcha.
Start the fourth semester this Friday.
The fourth semester, and then the third year they bore you to death. So anyway, this is a series where we are taking on topics. They don't teach you stuff in law school topics. And the idea is, you get the basics in law school, and then we will sort of hash it out in real world, with real world considerations here at the table. And I'm going to do something a little bit unique here. We're going to take a topic that you've been asking me about since we did our negligent homicide, manslaughter, etc. series or discussion. And then we're going to couple that with an answer to a question that we got from Paul over on TikTok. And Paul's question was, if negligent homicide is killing with a car inadvertently and the victim was the unborn, the law sees that child as a human, correct? Then wouldn't abortion be negligent homicide in the least? So this is like taking all this to the most hotbed topic you can possibly bring up in today's society. But here's what we're not going to do. We're not going to talk about whether it's right or wrong to have an abortion. All right, we're going to deal with this very clinically. And we're going to leave our sort of thought on the morality of it aside one way or another. That's for you guys to figure out, who am I? But what I think is these are interesting topics, or these are interesting considerations when we're kicking around the murder definition, et cetera. And, generally speaking, there's a lot going on as of late with abortion, with the U.S. Supreme Court reversing Roe versus Wade in the Dobbs decision and sending that, in essence, back to the states. That'd be another interesting breakdown. And then, the individual states and how they're sorting it out and acting on it. And then couple that with like the murder definitions and where we are. So you had some questions. I guess we'll start there.
Yeah. So in law school, we went over I guess charges on someone when somebody is pregnant. So if I were to kill a pregnant woman in law school, we were taught this is now double homicide because there's a fetus in there.
Yeah.
And so in my head, I kind of understand where this question from Paul is coming is, yes, like if we're defining at that end, why is it not defined as murder when someone else does it? It kind of makes sense a little bit.
Well, this is no, you're right. This is like one of those little, what I'll call conversational hand grenades I used to throw in when people were arguing abortion. I'd be like, yeah, but Ohio's murder law, for instance, says no person shall purposely and with prior calculation design cause the death of another or termination or unlawful termination of another's pregnancy. All right, well, that's interesting. So it's murder, so you get charged with 2 counts of murder generally. If you kill a pregnant woman, that's going to be 2 counts of murder. And there have been some states that had laws like this, and because of the statewide stance on abortion, they've amended some of their murder statutes to eliminate that language. Now, again, I'm not going into whether you agree or not, don't agree with it, but there's an incongruity to it. But there's a couple things that we should point out about that statute. First, this is the purposeful murder. And let me just, because our question was about negligent homicide, Ohio's got something called negligent homicide that says no person shall negligently cause the death of another or the unlawful termination of another's pregnancy by means of a deadly weapon or dangerous ordinance. So there's a negligent homicide statute that may or may not fit. Now, like anything in law, particularly criminal law, where you have statutory elements. So look at it like a checklist. So when I defend a case, and you've done this for me, we pull the jury instructions on what the jury's going to hear. And what I'm doing is we are figuring out the reverse of what the prosecutor has to prove. The jury's going to be instructed that this is the definition of the crime, and then we create a list. And the list in this situation would be no person shall negligently cause the death of another, so you can say the another, or the unlawful termination of another's pregnancy by means of a deadly weapon or dangerous ordinance. All right, well, that's interesting. Let's just take let's take the element of the unlawful termination of another's pregnancy. You catch the language in there that counts?
Yeah, the unlawful part?
No. The unlawful termination, which is good, you're good, but keep going. The unlawful termination of another's pregnancy. So that's not your own.
That's true.
That's another's. So the Ohio General Assembly has written this law. This is like, look, folks, definitions matter. And this is why, and look, wherever you stand on politically correct movement or the woke movement or whatever it is, I abhor this stuff where people start to change the definitional structure of terms, because we need to define them in order to have a an understanding of what the law prohibits and what the law permits. And once you start to blur definitions into different things, then it gets very difficult to actually apply any laws with any consistency. But there is the exceptions that matter are baked into the equation of these two offenses. Both say unlawful, which means it implies what?
That like you did it in a legal way. In my head, I'm thinking like,
well, no person. So you can't cause the unlawful termination of another's pregnancy. So what they're protecting there is doctors
who are doing it lawfully.
Who are doing it lawfully, right?
Yeah,
right. So that's not murder if a doctor does it. That's what they're saying. Now, what about your own pregnancy? So I guess there's two protections there: unlawful termination, meaning some other law permits it, and of another's pregnancy, which means you're terminating your own pregnancy. So
if I do a homemade abortion,
that could be murder.
Okay. Because
if you do it to somebody else.
And what if
this is like back alley abortion stuff you're talking about.
Yeah. That's what I was thinking when you said what's the word that sticks out. I was thinking unlawful. I was thinking like, what if I start, alleyway abortion services by
it's unlawful. Yeah. It's unlawful.
Mm-hmm.
And so but on yourself, that's a whole different story. Now, look, I've also had cases. There's a very famous case. I think it was State versus Hopfer, Hopfer, in Ohio, where there was a time when babies were sort of showing up on people's doorsteps, or like young girls, sadly, would get into these depressions and they would terminate their own pregnancy or have the baby and just sort of hide it, or it was stillborn or whatever. Horrible stuff, all the way around. And this is a case that you can go look it up or check it out in the Ohio Supreme Court. But that scenario happens. That's a little bit different scenario. But the other protection I guess we should go into is, since Roe v. Wade was reversed in Dobbs, hold on, my computer blacked out here on me. Ohio has passed a constitutional amendment. And I guess we can sort of talk a little bit about what Dobbs was and what it wasn't. So Roe v. Wade basically created a constitutional right to have an abortion. And again, you can agree or disagree with whether that was a good idea or not a good idea. But most scholars at the time thought, well, that's a big stretch, because if you check out the Bill of Rights or the Constitution, it doesn't say anything about abortion anywhere. And they sort of found this penumbrum of rights in the 14th Amendment due process realm. And we're not going to go into that, but let's just say there was a shaky foundation to it. Now, it became precedent, and it lasted since 68 was Roe. I don't remember. Maybe 70.
Right.
70.
Yeah.
Maybe 70. We'll have to look it up. But at any rate, Dobbs basically said, look, it was never a constitutional right. It shouldn't have ever been a constitutional right. This isn't a federal constitutional issue. So we therefore reverse Roe v. Wade. And it's not like we said we send it to the states like you may, but that's in effect what happens. It's like if the federal government doesn't have jurisdiction or authority over it, then in our system of justice, the states do. We have like these independent states that, and it's really sort of brilliant constitutionally what's going on. It's like, the states get to decide what they're going to do for the people that live there. So they're localizing this stuff. Now, again, I'm not taking a position on it. Agree or disagree with reversing Roe v. Wade, that's up to you. We're talking about the consequences of it, though. Mm-hmm. So then what happens is lots of states start to legislate on this stuff. And in several states, Ohio, one of them, created constitutional amendments to enshrine the right to abortion in that state. Now, look.
Ohio was really recent, too. I think it was like last year.
It was just last year.
Yeah.
Yep. And, it has some, I had it up. Here it is. It has some, let's take it out of the realm of abortion for a second. I hate constitutional amendments that are really just legislative acts. And let me tell you why. In Ohio, we have something called the General Assembly, which in federal court or the U.S. system, they call it Congress. It's two houses, and they pass laws. And the idea of Congress passing laws is you have individuals or our representatives literally on the floor debating topics, like presenting evidence. We have congressional hearings all the time where people are presenting facts, presenting evidence, and only then can you come up with good public policy. And then you have this representative form or representative decision. Now, you may not like it. Your rep may have voted the other way, but there's a democracy here. And then the law has a process, Anybody who's watched Schoolhouse Rock, I'm just a bill sitting here on Capitol Hill. It's got to go all the way up, and then the president gets to either sign it or veto it, or in the state system, our Governor DeWine either gets to sign it or veto it. And then if he vetoes it, it goes back, and they try again. The point is that it can change. There's a process for change. And when the difference being constitutionally, if you try to do that, pass a legislative law, except really call it something else, like a constitutional amendment, now you've enshrined it as a constitutional right. And the downside, what do you think the downsides of that are?
The downside, I immediately am thinking, is there's a difference between federal and state.
Forget about that. Let's just talk about at the state level or at the federal level. When you make something a constitutional amendment, there's some downsides. There's some upsides to it, but there's some downsides to it.
I can't think of what the downside would be. I mean, other than that, you're shaking up the entire judicial system. We have a new law that we have to then figure out.
Okay, so here's my perception of the downside.
Okay.
We'll talk sort of generally speaking. If we have a law that we don't like, and Congress passed it, or in Ohio, a General Assembly passed it, then the remedy is the voters can vote, and they can change it. They can pass a new law. They can repeal the law. They can amend the law. And the problem becomes, or the consideration is this. Let's say you take a topic like abortion that somewhat relies upon a scientific definition. So, for instance, in Ohio's constitutional amendment, it talks about the viability of a fetus outside the womb. And, that is specifically a vague definition.
Yeah.
But, or if you talk about something scientific that needs to happen, then you can't then go on the congressional floor or the General Assembly floor and present evidence, present testimony, give the voters facts about the changes or the new science or the new laws or whatever it is. So in other words, almost all of this stuff, all of the Ohio's constitutional amendment could have been done with a law.
Yeah.
Right? It could have been done with a law. Now, the people who are in favor of abortion, they don't like that because then it's too easy to change the law. They want a right to abortion. The people that disfavor abortion, they want a law because they want to eventually get the grassroots votes enough to repeal the law. I get it. That's the debate. But when you try to legislate through a constitutional amendment, you're enshrining a controversial problem into a constitutional amendment that makes it very difficult to change. And then if in its application you run into issues such as when is a fetus viable, then it makes it harder to make amendments to that because now you've got to amend the Constitution, not just add a section to the law or take away a section to the law. So it's got its pros and cons. And look, people, I've debated this with folks all along, and I feel this way about almost all constitutional amendments, right? In the federal system, there's, as I always say, if you want a constitutional right to abortion, there's a process for it. You can just you can amend the Constitution and add an amendment. And, people say, well, that's no good because we won't get it passed. Well, then you didn't get it passed.
So you're saying that your issue with it being a constitutional amendment is they've built, instead of a straw house, which would be like a law, they've built a concrete house. And if you want to change or destroy that house, the concrete house is obviously going to be a lot harder.
It's a lot harder to change it.
Yeah.
And I'm not even saying repeal it. I'm just saying change it or modify it, even in a way that everybody would agree with. So now we're stuck. Now we've got this, and it reads like a law. Interestingly,
I mean, when you were saying the language and you're saying how it's vague, the other thing I'm thinking of now is
the Constitution should be vague, but go ahead.
And is now we then have to start building case law on it to fill this vagueness, and there's going to be.
That's correct, and that should happen on the General Assembly floor.
Mm-hmm.
Cases shouldn't pass law; they should interpret it.
Yeah.
All right, so here we go. In Ohio, every individual has a right to make and carry out one's own reproductive decisions, including but not limited to decisions on contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion. The state shall not, directly or indirectly, burden, penalize, prohibit, interfere with, or discriminate against either, 1, an individual's voluntary exercise of this right, or 2, a person or entity that assists an individual in exercising this right. unless the state demonstrates that it is using the least restrictive means to advance the individual's health in accordance with widely accepted and evidence-based standards of care. However, abortion may be prohibited after fetal viability, but in no case may such abortion be prohibited if, in the professional judgment of the pregnant patient's treating physician, it is necessary to protect the pregnant patient's life or health. And then they give us a bunch of definitions. As used in this section, fetal viability means the point in a pregnancy when, in the professional judgment of the pregnant patient's treating physician, the fetus has a significant likelihood of survival outside the uterus with reasonable means or with reasonable measures. This is determined on a case-by-case basis. And then they define state. It sounds like a statute.
Yeah.
Except it's a constitutional amendment. And the problem with this is, what if you have to change the definition of one of these terms? Or what if you want to? Like we're sort of presuming a very specific format here. And look, I'm not suggesting, look, I have my own position on abortion in my personal affairs.
Mm-hmm.
It is what it is. But if you wanted to make abortion lawful in Ohio, I would have suggested that you pass a law, not make a constitutional amendment, at least not an amendment like this.
I agree with you on that. I mean, it's going to be kind of exciting to see how it rolls out over the couple of years and the case law coming out on it. I would like to see. Another thing I was really alarmed with is the overseeing physician. Like, for all I know, now we're going off a doctor's opinion, and that's going to vary between every single doctor. It's going to be interesting to see.
It will be interesting to see it, right? So look, I mean, like it or don't like it, we have a constitutional amendment in Ohio that says what this says. Now, this reads like a law, like a statute that you would see in the Ohio Revised Code. It even has its own definitional section, which is a typical statutory type scheme. It does not read to me like a constitutional amendment, but in Ohio, there's been other areas recently where we have decided as a state that we like this stuff, and we're sticking a bunch of stuff in the Constitution. Fair enough. I can gripe about it. I can pound the table about it, but it is what it is. We have it. And like you said, it'll be interesting to see how it gets interpreted. And you could take this debate, folks, away from abortion. Like I don't mean this to be a pro-life or pro-choice debate. It just is. How does the state get to it? And I think you're going to see a lot of grappling with this at the state court level now that Roe has been reversed. And I suppose on a good level, it's happening at the grassroots level, and we'll see how this happens. Now, the other big question along these lines is whether the federal government can pass a law. Can Congress pass a law that enshrines abortion or that allows abortion, and then apply that law to the states? We shall see. There's some other interesting constitutional arguments to be made there, but we'll see what happens. Which is why during the presidential election you saw everybody asked, are you in favor of a congressional law that says this or this about abortion? So we'll watch how that sort of unfolds. I'm fascinated by the constitutionality of this stuff, or by the academics of it, more than the actual morality of it.
Can we circle back to Paul's question here? I got something that I thought up of. It sounds a little eggshell skull.
So
eggshell skull rule here.
Let's go back to Paul's question. If negligent homicide is killing with a car inadvertently, and the victim was the unborn, the law sees that child as a human, correct? Then wouldn't abortion be negligent homicide in the least? So I guess we've sort of answered Paul's question. We'll get to your follow-up in a second, but we sort of answered Paul's question because there is a way that it is negligent homicide for Paul, or for the other car, the driver, the person charged, could be charged with the negligent homicide of the unborn child. But the woman who is getting an abortion for herself, under the definition, could not. Mm-hmm. And now in Ohio, we've got the constitutional law that protects it.
So my follow-up question on Paul is imagine I get in a rage, my ex-girlfriend, I get all mad at her, and I decide to shoot her, right? I didn't know she was pregnant. Am I still wrapped up on double homicide, or am I going to, because I didn't know she was pregnant, am I going to get hit with something less for No,
probably not. So here's the thing. It's a great question, because in criminal law, you've learned this in your criminal law class your first year. in common law times, go way back to like the Normans and the Norman conquest and the development of our Western system of criminal justice, you needed two things. You needed the mens rea, which is like the mental element, what's going on in your head. So you had to have some sort of criminal intent.
Yeah.
And then you needed an actus reus, which is the act. In other words, you have to have an act. And in some very limited circumstances, you have a duty to act and you didn't act. But let's just take the act. So I have to have the mental element, and then I have to have the actual physical side of it. So the example I always gave people is that, I may have even told this example, if I borrow your pen and forget to return it, have I committed theft? Well, in modern times, we define theft as purposely depriving another of his property without consent. I mean, I've made that up, but generally that's what it is. And the element, the mens rea element or the mental element is I did it on purpose. Mm-hmm. And the act is I took your property. I deprived you of your property. I took it. Mm-hmm. So if I did it with something less than purpose, I did it maybe accidentally, I haven't committed theft. Now, if the law said it's a negligent theft, then I did do that. Okay. But anyway, what was your, now let's get back to your question.
So I had the purpose intent. I understand I have the mens rea for why I killed her.
That's
but
right.
I don't have the purpose for killing the fetus because I didn't know it was there. Is that then more like involuntary manslaughter we're thinking?
So let's look here. No person shall purposely, with prior calculation and design, cause the death of another or the unlawful termination of another's pregnancy. So the argument we would be making at trial for my client, if you were charged with purposely murdering your girlfriend and you didn't know that she was also pregnant, we would be arguing to the jury to apply that purpose to the unborn child because you didn't know. You didn't do that on purpose. You killed her on purpose maybe, but not the unborn child on purpose. As a practical matter, you're going to prison probably for life, 15 to life anyway.
Yeah.
But leave that aside. But it's a great academic question. But it doesn't, the other side is going to be saying, look, the act is what is purposeful. Mm-hmm. The act of killing is what is purposeful. The causing is not. Now we're going to say no. The mental element applies to all of it. But so you could act in such a way. So if I throw my fist on knowingly and I hit you in the jaw, and I knowingly threw my fist with the understanding of it'll have certain consequences. So there may be a defense if you didn't know your girlfriend was pregnant. But there's another, let's take it back to the negligence. Maybe you should have known, or maybe you disregarded a known fact and you did it sort of recklessly because maybe your girlfriend said, "Hey, look, I'm late."
Okay.
So maybe you should have known, and then maybe a lesser mental element might apply.
Okay.
So like lots of legal questions, it all depends.
Yeah. I was thinking like a tort law eggshell skull, like in my head, too sad. Like you didn't know she was pregnant. We're still going to slam you with it.
Great question. No, that's great. So in torts, the difference between torts and criminal law. Criminal law is you've committed a crime. You can go to prison. You can go to jail. There's a consequence, and it's the state of Ohio or the state or the Commonwealth or the people versus you. A tort is where I sue somebody. And look, I didn't understand this the day I entered law school. I figured it out. But like most people, I don't say most people, I didn't quite understand what the difference was. It's similar but different, right? It's not the plaintiff in a tort, in a civil lawsuit is you if you sue somebody. The defendant in a civil lawsuit is the person you're suing. The plaintiff in a crime is the government, the state of Ohio, the United States government, the city of Columbus. That's the plaintiff in a criminal case. All right, so a tort is a little bit different. You don't have constitutional rights. So you don't have a right to counsel if you're sued. You don't have a right to make them prove their case beyond a reasonable doubt if you're sued. The other side has a burden, and the burden depends on what it is, but it's a little bit different. So if you hit somebody and they sue you, the individual you hit sues you because they happen to have a blood clot in their brain that caused, let's say they became incapacitated as a result, and actually they've got a guardian that's now suing you. It doesn't matter then that you knew or didn't know that they had an eggshell skull, because the eggshell skull is like the sort of the vernacular you use in law school to say all right, this person was fragile. I didn't know this person was fragile. They should have been able to take that little light slap I gave them. But this individual had an eggshell skull. Or this person I hit in my car, I didn't know they were pregnant. Therefore, it shouldn't be. I shouldn't be responsible for that, or I should be responsible for that. It's different depending on whether you're dealing with criminal law or whether you're dealing with civil law.
Okay, so criminal wise, we're not applying it, but
Well,
on the civil lawsuit side, I'm going to get hit with 2.
You're probably going to be hit with the Yes, you would be hit with 2. That would go into the damage section of the tort, in all likelihood. And even on the criminal side, it's not like we're not going to. But in order to figure out if you can, it's a little bit different. You have to go check out the elements of the offense and see if they apply. And if they don't apply, then the answer is no. If they do apply, then watch out. You could be convicted of that too, assuming the state proves their case beyond a reasonable doubt.
Okay.
All right. So they didn't teach any of that crap in law school.
No.
I didn't even know they taught me that. I don't even know where. This is just stuff that requires. Maybe this is what's great about law school education. They give you an analytical framework to deal with issues in a non-emotional way. I can look at the abortion decision and separate my morality from it one way or another. And I think, and those who don't, they suffer. Their analysis suffers. If I, as a lawyer, get too far ingrained emotionally or personally into an issue, then I probably shouldn't be grappling with the legalities of it. I should be able to look at it like a computer. And this is why people hate lawyers. And I always say this, I hate lawyers because we're trained to do this. And it's like I don't care about your feelings here, dude. It is what it is.
Shawshank Redemption calls lawyers a bunch of ball-washing bastards.
A bunch of ball-washing bastards. And who am I to disagree with that? But it's like, look, we are trained to deal with these things in an analytical way, not an emotional way. And when the emotion gets in the way of that, the analysis suffers. So whether it's abortion or whether it's widgets, I would treat this the same. Now, it's not lost on me that the consequences of what we're figuring out, the consequences of the decisions that are being made, whether it's by the government or whether it's by the Supreme Court, whatever it would be, I mean, it's huge. It impacts morality, but you shouldn't analyze them with morality. Now, I'm sure there's going to be lots of you out there that disagree with me, but that's how I look at this. I'm not unsympathetic to all this stuff outside the legal analysis. But inside the legal analysis, if we start baking into our assessment the emotional considerations, then the outcome will suffer. And we are going to legislate and create law that is or that leads to absurd applications beyond the scope of what we're trying to do.
Yeah.
In other words, in logic, they used to call that reductio ad absurdum. It gets reduced to absurdity. Like if you carry it to its extreme, it results in unintended consequences.
Yeah.
That's why we have to be careful creating constitutional amendments or making new laws or just saying this is wrong or this is right. We have to look at the definitions. So look, do I agree or disagree with this? Maybe we can have that discussion. But analytically, I can understand why this law doesn't apply in the scenario necessarily that we're discussing. So it's not abortion. This doesn't prohibit abortion because it says unlawful termination of another's pregnancy. Look, the definitions matter.
Yeah.
And they do teach you that in law school, but they don't necessarily teach you the ramifications in the real world and how it gets applied. So look, that was a great question. And Paul, thank you for your question because these are the things, it's actually a lot like law school, isn't it?
Yeah.
That kind of question is like, well, yeah, but what if?
Mm-hmm.
What about?
I will say though, in law school, there's some people who go on the what if train for half the class, and I'm like, hey man, we can paint every scenario possible. We all know it depends. Like, why are we going? If you want to go case by case, pull out Lexis, pull out Westlaw, start figure it out yourself here. Like I don't know. That is one thing that bothers me in law school. So
look, law school, they used to say it feels like you showed up for the game and somebody's hiding the ball. Like you don't even know where the ball is. You don't know and really what they're saying is, and what you're getting at is there is no right answer often. There's sometimes the best answer, but really the right answer is there's multiple answers, which is the simple way to say that is it all depends. Mm-hmm. It all depends. If you define the charge this way, then this is the outcome. If you defined it this way, then that's the outcome. It all depends. And you just have to understand that. And, at the end of the analysis, it never gets to a complete perfect point, but it gets you close. And then that's where the play in the joints happens.
I think one of the things I really noticed the first year, last year, was there was a handful of people who would take a side that this is the right side, this is the for sure side that's going to win, and the other side's completely wrong. All those people failed out or dropped out.
Mm-hmm. If you're looking for a right answer, you're wrong.
Yeah, I was like, and I would always tell them, like, you understand that this case was 50 years ago. The reason we are still talking about it today is because you can go either side. You can make amazing arguments on both sides. If you're going to shut out the complete other side, you're not here for the right. You don't understand what's going on here.
So here's the tip for you folks entering or taking law school exams, the traditional handwritten, or you probably type them now.
We type them now, yeah.
The typewritten essay questions. The professor will give you a factual scenario.
Yeah.
Not unlike what we've talked about.
No.
And then they'll ask, can so-and-so be prosecuted for this? And your answer is, it all depends. Yeah. And what the professor's looking for, whether he's telling you this in law school in advance or not, what they're looking for is your analysis of that. Well, side A will argue XYZ. Side B will argue something else. And maybe there's a side C or a small minority that will say something totally different. And then, only then, can you say how you would resolve the conflict. Mm-hmm. And that answer doesn't matter.
No.
And if it does to your professor's not doing you justice. They are making the mistake that I talked about, like entering into this emotional, I think the decision should be this. So anybody who says differently, well, you're getting a D.
Yeah.
The real question is, how did you get there?
Yeah. If you look at a grading rubric, your essay will be 100 points. 1 point of it is your conclusion. They just want to see that you put a conclusion. Like, I think so-and-so should win. That's all you got to write. All they care about, 99% of it, is how you argued both sides. And people really struggle with that, and it just doesn't make sense to me. Like, that's the whole reason we're here.
So everybody says, like, not everybody. There's this idea that a lot of, like, the engineer-type mind would be a great law student. It's not true. It's not true. You have to think abstractly, because engineers look for answers. Look, I'm not saying engineers can't do this, but let's take it out of the engineer realm. I didn't mean to insult engineers, because I know quite a few. In fact, I almost was one.
My roommate will have some issues with saying, I'm sorry.
Yeah.
I'll let him know.
But I'm using as an analogy the folks who think that there's a bright line answer to these questions, and they're so sure that they're right. There's a great, and maybe even they are, but that doesn't make you a good lawyer. In fact, maybe the opposite. You have to see the other side, and you have to understand that there is no right answer. There is no perfect answer, maybe only the best one. And sometimes the best one is only marginally better than the second best. And sometimes it's the same, and it's just your opinion. But as long as you say that, you get an A.
Yeah.
It's really easy.
And people still struggle with it.
What I learned early on in law school, and for you budding young law students out there, you read how many cases a week?
Oh, a week? I would go over under, like, in the classroom setting, like 35, not counting what like I do here at work.
Yeah, and then at work you're reading another 35. Right?
Yes, yeah.
Now you understand, like you have learned the rhythm to appellate court decisions. Mm-hmm. They say what the facts are. They talk about what the person's arguing. They analyze that argument from both sides, and they reach a conclusion. They say, well, look, and the analysis could be as simple as like, yeah, I know what he's trying to say, or what this defendant or this litigant's trying to say, but other courts and I have already decided this 100 times over, and it really means this. Their argument is this, but the other courts have already decided this, so therefore we hold with the other courts, and that's that. Or if it's a new issue, then the court will simply give an analysis. The state's arguing this, the defendant's arguing this. Even though this is a case of first impression, meaning we've never heard it before, we're going to conclude this, and that's that. If you follow that format and you read 70 cases a week or 30 cases a week, follow that format in your exams, you'll get an A.
Yeah.
If you recognize the issue correctly.
Yeah.
So, all right. Well, they don't teach you this stuff in law school. I know that because I was in law school, and you're in law school, and you say so too. Look, Paul, thank you for your question. It's a great question. I love this kind of thought-provoking discussion. I think we took it in a place maybe you didn't intend, but that's okay.
Yeah.
It's my podcast. Right. So anyway, lawyer talk off the record, on the air. Law school. They don't teach you that in law school edition. Each and every week, at least until now.